and found that the government had not used the least restrictive means of serving the government's compelling interest. The law was not narrowly tailored because there was available other means of achieving the government's purpose, namely credit card billing, that instead of just putting it on your phone bill, which was great for the dial-tone companies because everybody would pay their phone bills, instead of telephone company billing, the dial-tone operators could use credit card billing, and that would be likely to screen out a substantial portion at least, of the minors who might be trying to get access to dial-tone. And because of the existence of that less restrictive means, the court determined that the law was not narrowly tailored and struck it down as a violation of the First Amendment. But the Congress got the message immediately, and Congress passed very quickly a new law that also prohibited putting indecent material for commercial purposes on the phone, but provided a safe harbor. You won't be prosecuted if you engage in credit card billing. And my understanding is that that's what the industry did and does now, that it's all operated by credit card billing, not phone company billing, and the industry continues to thrive. What about the obscene prohibition in that phone sex law? Well, as we know, obscenity is not protected speech in any medium. But the dial-porn industry argued that because of the community standards element of the definition of obscenity, their constitutional rights were violated. That is, a dial-porn operator based in San Francisco, conversant with the community standards of libertine San Francisco, shouldn't be subjected to prosecution when somebody from Greenwood, Mississippi calls him up, or Logan, Utah calls him, some conservative community anywhere in the country might call him up, access their services, and that would trigger a prosecution, and the prosecution might well take place in Mississippi or Utah. Well, the operator said, look, we know what our community standards are, and we comply with them, which may not be true. It's virtually impossible to know what any community standards are, but anyway, their argument was we shouldn't be subject to prosecution if somebody calls us. We can't help it from somewhere else, not our target market at all. And the court slapped that argument down, saying, basically, if you're in this high-tech business, you can figure out a way to block the calls from communities where you don't want to be subjected to their community standards. So the obscenity provision of the phone sex law was upheld. And then, before we get to the internet, there's the violence question. I put in the reader portions of the FCC's 2007 report on television violence. They had been asked by members of Congress to inform the Congress what action the government could take or should take with regard to what the Congress viewed as excessive television violence. What's that called? Well, so if something is obscene, it is certainly indecent. No question about that. But something that is indecent may not be obscene, because the working definition of indecency plucks out only that middle part of the obscenity definition, the patently offensive part, so that it can be indecent even if it doesn't appeal to the prurient interest, even if it does have significant social value. So the universe of indecent speech is large and apparently infinite in the government's view, but the obscenity is a hardcore concept. So violence, the FCC, this is the Bush administration's FCC, comes out with this report that said the kids watch enormous hours of television, and it includes all kinds of violence, and it's very upsetting. And what can we do about it? And the FCC report concludes that Congress could impose time channeling restrictions on excessively violent television programming in a constitutional manner. That is, the government has a compelling interest in protecting children from exposure to excessively violent programming, and time channeling would be a narrowly tailored means of protecting that interest. Time channeling of the kind that the FCC was very familiar with regard to indecency. That is, during the hours of the day, 6 a.m. to 10 p.m., when children are likely to be in the audience, that's when you can't air this stuff. But what the FCC did not do is attempt to define what would be excessively violent programming. What the FCC says is, if properly defined, excessive violent programming could be prohibited by law, by the Congress. And it goes on to say that this excessively violent programming occupies a relatively low position in the hierarchy of First Amendment values. It's low-value speech, they're saying, because it is of, quote, slight social value as a step to truth. It doesn't assist us in getting to truth. That's a quote from Chaplinsky, the famous Jehovah's Witnesses case that established the fighting words exception. And whether the FCC is right that violence occupies a low position in the values of the First Amendment, the Supreme Court has not said that, except in Pacifica, where it said that indecency lies at the periphery of First Amendment concerns. And the question is, should violence be treated the same as indecency? What do you think? Nicole? Mm-hmm. Mm-hmm. So, Camille?
I think it would be kind of hard to excessive violent programming because it probably depends on how you shows, but then it seems like if you were getting news stories, maybe about, I don't know, like Boston bombing, like that would be like, excessively violent, but you can't really expect news broadcasters not to like, show things like that. You know, people doing this violent, and not going to fall into under accepting that.
Couldn't you, as a congressperson, couldn't you write an exception in your law for news?
Probably said that then there's kind of like a fine line, like news or like a documentary.
Yeah, what if it is a documentary? Case? Yeah.
Which would then require tailored, require the it would be. I mean, based on what we've seen, it's really hard for a government to impose content-based restrictions. Which I mean, the other thing I think this violent thing back in the East is a horrible idea, but that it seems like it's based on what it's sort of hard for content-based to get through.
Right. I think we can safely assume that a law that says that excessively violent programming on television is content-based. I mean, that's what it is. It's content-based, which triggers strict scrutiny. Would it survive? FCC says there's a compelling government interest in protecting children from exposure to it. So the question is one, as you point out, of narrow tailoring. Can you narrowly tailor a law to serve that interest? If you included news, wouldn't we say that's overbroad, over-inclusive, and violates the First Amendment for that, but you can do an exception for news. Maybe an exception for documentaries. How about Shakespearean plays? How about Macbeth, incredibly bloody play? NFL football. Nicole? Yeah, so to be even-handed and thorough about it, the government should ban excessively violent images on the internet as well. Good luck with that. Yeah. I'm wondering, though, you raised the question of, it depends on how it's defined. I challenge you, write it out, put it on our website or bring it into me, and show me the definition of excessively violent programming that will be deemed to be constitutional, consistent with the First Amendment. Maybe you can do it, but I can't take it away. Say you? Say that again? Addressed it in the context of video games as a medium of communication. But doesn't television have different unique characteristics than video games, which you go down and purchase and you bring home and you put on your own thing? It isn't ubiquitous, it isn't pervasive, you pay for it, you opt into it, whereas broadcast comes into your home unbidden. So using the rationale of Red Lion and Pacifica, you would say the broadcast is different and can be treated differently by the government, for better or for worse. Well, the FCC report on violence considers the availability of less restrictive means than a flat-out prohibition of violent programming, like the V-chip. Everybody familiar with the V-chip? Has anybody ever programmed a V-chip? No. Do you know what one is? No. Every television set sold in the United States since January 1, 2000 is required to have a V-chip in it, put there by the manufacturer, so that parents can program it and screen out broadcast material that they don't want their children to see. Did your parents ever do that? Anybody? Well, the FCC sort of does conclude that the V-chip is not an effective means of serving the government's interest because people don't know about it, and people don't use it if they do know about it. And the V-chip technology depends on the reliability and accuracy of the ratings put on the material. And there is a voluntary rating system for television. Anybody familiar with that? I'm not either. But it exists, and you could program your V-chip so that, or your cable box, you could do it separately, to screen out material that has been rated in some way excessively violent. Julia?
If parents aren't even using the V-chip, then what does that say about like, the FCC regulating broadcast? Which parents aren't even here, they do regulate stuff. They're not even using like a VM already.
Right. Well, what does it tell you about our society that we at least say we are regulating indecent material, but we're not regulating violent material? Both are somewhat quixotic ventures, but what does it say about our society that we officially object to indecent language and images, but we don't officially object to violence? I do think that the violent video games case, if this became law, that would be prominently featured in any argument about the constitutionality of the law, and the court's reasoning would be used. The court could distinguish broadcast as being different for reasons that we know very well now, but the idea that there's so much in the way of violence pervading our society, from Grimm's fairy tales to Macbeth and everything in between, that you can't single out the violence available in one medium and say that has to be squashed. Something else? You mean cartoon, Saturday morning cartoon? Yeah. Yeah, well, Justice Scalia thought allowing that undercuts the need to outlaw violent video games and so on. So V-chips don't do any good. They didn't think the rating system was any good. People didn't know about it. They didn't trust it. And in fact, there's some evidence that the more scary the rating is, the more kids want to see it. Sort of like the warnings in the Hustler magazine article case. So that none of those things work very well. Therefore, you ought to go to time channeling and maybe consider a mandatory rating system. But you can't have a mandatory rating system without a workable definition of what you're dealing with. And I don't think you can come up with such a definition. So, pause, stretch, tune out for a second, and we'll go to the internet. And when the internet came on the scene, one of the initial questions will be, how would the Supreme Court approach this new medium of communication? And not too surprisingly, the Congress couldn't tolerate having this unruly, powerful beast be unregulated. That here's this new medium of communication sweeping the country and the world, and we're not doing anything about it. And we're, for example, notoriously, the internet is filled with smut, with dirty pictures, and sexually tinged material. So the Congress enacted almost unanimously, our senators from California voted for it, the Communications Decency Act of 1996, which is the most sweeping restriction of the speech of ordinary people that the Congress has ever enacted, or even attempted. And the point of the law, as the point of so much of this other attempted regulation of the various media, was to shield children from exposure to sexual material on the internet. So the Congress enacted this statute, which had two provisions. Section 223A prohibits obscene or indecent messages to any recipient under 18 years of age using a computer. That is, sending a communication which is obscene or indecent, knowing that the recipient of the communication is under 18 years of age. That's sort of like an email. I mean, that's the obvious use of that provision. And the second provision, subsection D, is different. It makes it a federal crime, a felony, punishable by up to 5 years in prison, to display on the internet in a manner available to a person under the age of 18 a communication that depicts or describes in terms patently offensive, as measured by contemporary community standards, sexual or excretory activities or organs. I overstated the prison term. It's 2 years, not 5. So the two provisions: one, sending an obscene or indecent communication to someone who's under 18, and displaying on the internet material that, they don't use the term indecent and they don't use the term obscene, material that is patently offensive in its description or depiction of sex, which of course is the middle part of the three-part definition of obscenity. It's the part that was used by the FCC as its definition of indecent. But it doesn't say indecent. It says indecent in the first section, doesn't say anything except patently offensive in the second one. Well, as soon as the law was passed, the ACLU promptly sued, and they sued the Attorney General of the United States, Janet Reno, because she is in charge of the federal criminal prosecution apparatus. And if you want to challenge the constitutionality of federal criminal law, that's what you do. You sue the Attorney General, who's in charge of administering federal criminal laws. Janet Reno was a law school classmate of mine. We sat in classes together, just like this, but not about the First Amendment, unfortunately. I can't believe that she could believe the arguments that were made on her behalf in the Communications Decency Act. Maybe she was just doing her duty. She was Clinton's. Clinton signed this law. She was his Attorney General. The ACLU, when it sued, did not challenge the obscenity provision of the law, just the indecent part and the display part in a patently offensive manner. And the CDA, as it was called, the Communications Decency Act, cast an uncertain but certainly wide net of criminality over online speech. It was not limited, the law was not limited to material that appeals to the prurient interest. It wasn't aimed particularly at the porn sites available on the internet, many of which originate abroad. It was not limited to commercial speech, the way the phone sex law was. Because it didn't have that third part of the obscenity definition, material could be illegal under the CDA that in fact had socially useful and important literary, artistic, political value, and so on. And it included this community standards provision, which has the potential for subjecting online speech to the community standards of the most